Getting away with murder may have just gotten a little easier. Florida's laws on self-defense just shifted sides, something a former judge says could have dire consequences for your safety. Our Adam Weiner explains.
The next time someone is charged with a violent crime in Florida, the case could go very differently.
This is what we call downstream consequences. The social policy that is set by this is really horrible.
Law professor Jeff Swartz says right now it's up to the accused to prove they should be immune from a jury trial. But legislators like bill sponsor Jeff Brandes of Pinellas County aim to change what's called the burden of proof.
Consistent with our historical law, the state should always have the burden of proof in these types of situations. The state should always have to prove that that you acted outside the law.
But Schwartz, a former Florida judge, warns the change means it will be up to the state to essentially prove guilt to a judge before the trial ever even happens.
All rise.
And could mean a lot fewer violent crime cases ever make it to trial.
The idea that anybody who's charged with a violent felony can make the state prove him guilty twice, as opposed to him having to prove that he's entitled to the immunity and letting a jury decide whether he's being truthful or not.
So what does this mean for you? Well, it could mean a lot less power in your hands, since judges will end up making a lot more decisions instead of a jury of your peers. And Swartz warns that in a system where witnesses are essential to getting a jury trial, violent crime could become a lot more common.
Where people believe that they can get away with it because there's nobody watching.
Changes to the Stand Your Ground clause would take effect as soon as the governor signs it into law. In Tampa, Adam Weiner, ABC Action News.